Hi there. This is another video for HSC Legal Studies Human Rights topic. And right now we're going to cover the topic on statutory authority and human rights. Now, the topic is often not very well covered in textbooks, in my opinion. Usually it's a very short paragraph. But however, I'm going to try to give you enough information so that you feel confident in writing a 7 or 8 marker on this question if the question is very specifically referring to statutory authority. Okay, statutory authority, what is it? Well, in general, basically, they are legal authorities set up to monitor compliance with regards to certain human rights law. So they could be set up in regards to either treaties. So these will be UN treaties. So some examples of these treaty-based UN committees would be like the UN Human Rights Committee, which is set up to monitor compliance with regards to the ICCPR. There is another committee that you might be familiar with. That would be the UN Committee on the Rights of the Child. That's set up to monitor compliance with regards to the Convention on Rights of the Child, and under the optional protocols of the Conventions of the Rights of the Child, it also monitors compliance with regards to child soldiers, children in armed conflict, and also children that are caught up in people smuggling or children who are caught up in child pornography. Okay, and then there is the other form of statutory authority. This is known as domestic statutory bodies or authorities. And the main one I probably want you to really memorize, I guess, is the Australian Human Rights Commission, or HRC, formerly referred to as the Human Rights and Equal Opportunity Commission, HREOC. But the one you must remember is the AHRC, the Australian Human Rights Commission. They are set up they are set up by legislation. So all these domestic statutory authorities are set up through legislation. Then there's the other one called the New South Wales Anti-Discrimination Board, also set up through a state legislation in this case, whereas the AHRC is set up through federal legislation. Okay, so let's go to the human rights community, which is probably one of the most important treaty-based community within the United Nations with regards to human rights law. They promote participation in regards to standards of ICCPR. So it is specifically focused on ICCPR. Most of the work are focused on persuasion and also on promotion of human rights. Most of the time, they basically do that through receiving reports and commenting on these reports from member states, or they could do investigative reports on certain issues around the world. They also have an 18 committee. They also have an 18 committee member that consists basically of experts on human rights issues, and they do issue quasi-judicial rulings. Okay, now these are called views, but it's not so important, I think, for an exam whether you remember that they use the word views or not. But I think it's more important that you refer to them as quasi-judicial in the sense that they do they do kind of resemble judicial rulings, but these rulings are not binding on the parties in disputes. There's the other one that you probably don't need to remember for the for statutory authority, but it would be good for you to remember uh, more so for family topic and also for later on when we do child soldiers is the UN Committee on the Rights of the Child. Again, 18 independent experts, and again they do monitoring and reporting. They also, again, as I said earlier, monitor compliance in regards to the protocols regarding children in armed conflict, OPAC, and also regards to children, child prostitution, and child pornography. So they most of the work really resembles diplomacy, but again, there are some quasi-judicial functions in its body as well. Okay, let's jump to the point. How effective are they? Which is probably what most exam questions are going to revolve around. Well, most of the work really are persuasive in nature, and most of the work bind really are more about promoting norms. And so they basically investigate uh, uh, allegations of non-compliance, or they okay, and this could be either based on complaints or it could be based on general awareness of what's going on, and they need to find out further. They do receive reports of from member states about how well they're doing in regards to their compliance with ICCPR, which usually then get commented upon by these experts. Now, of course, they don't necessarily lead to enforcement of compliance. So these are really about persuasion. These are really, in international law, what we call norm enforcement, norm building. They do, as I said, have quasi-judicial rulings, but these are not binding again. So yes, you can probably question their effectiveness in of these committees if their quasi-judicial rulings are not binding. However, I would suggest to you that a lot of times member states do comply with these quasi-judicial rulings. They do have good reason to comply with them. And for those of you who do well order, you should be aware on how to deal with it, but you probably don't need to deal with it in a 7 marker. Okay, so one example of a quasi-judicial case would be the Tunin and Australia case. This is where this involves basically a man by the name of Tunin who was a gay Tasmanian. And at that time, Tasmanian law criminalized homosexual acts among men. So he took the case initially to the High Court, arguing that basically that Tasmanian law was unfair and unjust. But however, the High Court ruled that basically the law was, was outside the federal jurisdiction. So he took it to the UN Human Rights Committee. His argument basically was that Australia, through the state of Tasmania, violated the ICCPR, or is in breach of ICCPR. And the committee ruled in Tunin's favor, basically agreeing with him. So this activated basically Section 51 of the Australian Constitution. If you recall Section 51 of the Australian Constitution, the right to conduct foreign affairs, and that includes signing treaties and complying with treaties, is part of the exclusive powers of the federal government. And because the committee ruled in favor of Tunin and therefore against Australia, and because Australia is a signatory to the ICCPR, that gave the federal government the opportunity to basically overrule the Tasmanian state legislation with regards to homosexuality. And as a result, basically, that led to the decriminalisation of gay homosexual acts in Tasmania in 1993. Right. The other case, however, demonstrate that compliance don't always work, and that in the end of the day, because of state sovereignty, member state can choose not to comply with these rulings. This is a case involving a guy called Blessington who was sentenced basically to jail for life as a young boy because the horrific nature of his murder and rape of a woman by the name of Janine Bolding. And his crime was so horrific that he's been denied paroles many, many times, and he's now around more than 40 years old. He tried to, however, make a complaint to the UN Human Rights Committee in 2014, and the argument was that Australia was in breach of not just ICCPR but also the CROC, the Convention on the Rights of the Child, on the basis basically that it was against international human rights law for him to be detained as a young boy at that stage for life. Now, the Human Rights Committee did rule in favour of Blessington, basically suggesting Australia was in breach of both ICCPR and also of CROC. However, there hasn't been any attempt by the federal government to put pressure on the state government to basically grant parole to Blessington. And no doubt there is just no political mileage to be made out of granting parole to a man that is still reviled by the many in the community as for what he did many, many years ago, back in 1992. All right, so that demonstrates basically that at the end of the day, these rulings are not binding. Member states do make the choice of making it binding, but sometimes they don't make it. Sometimes they can choose not to make it binding. We don't have that problem with domestic statutory bodies because these are acting under domestic legislation. One example of this will be the Australian Human Rights Commission. Okay, so this is not a court; it's a statutory body. It's created through the Australian Human Rights Commission Act 1986, formerly called the Human Rights and Equal Opportunity Commission. Guess that AHRC is less of a mouthful, I guess. Right. What do they do? Well, they monitor compliance, and they also make um, quasi judicial rulings on these legislations. So, any issues regards to racial discrimination, that could be, for instance, racial discrimination in workplace and so on, or services. Also, they deal with something that at the moment seems a bit controversial at the moment because of the current political debate. This is the clause on called Section 18C, which basically outlaws racial vilification. So basically, if you make a public speech vilifying someone or a group on the basis of, on racial grounds, then you potentially could be in breach of Section 80C of the Racial Discrimination Act. And we will have a look later on at the case Jones and Tobin to see how that works. Sixth Discrimination Act, 1984. That, by the way, ratifies not just the ICCPR, but also the UN Convention of the Elimination of Discrimination Against Women. And yes, it outlaws discrimination against women in workplace. So basically, you can't discriminate against someone on the basis of gender in employment or in provisions of services. There are some exemptions to that, but we don't need to go into it for the sake of a 7 marker. Also, we outlaw sexual harassment in the workplace. It absolutely outlaws it, and there have been some famous cases in that regard, and I will upload some media articles on that on the online portal. These legislation are also part of the Australian Human Rights Commission, so sex disability, age discrimination. But I think for a 7 marker, you only need to remember those two in particular: the Racial Discrimination Act, Sex Discrimination Act, and basically go into a bit of details. Make sure to remember your case laws, and make sure you're able to describe them. But again, if you can remember these four legislation, I think more power to you. Okay, so what do? AHRC basically do two things. Number one, they monitor compliance by the federal government. So they want us to basically monitor to see how the federal government comply or not comply with its treaty obligations. So it's an interesting feature of the Australian legal system that we actually set up a statutory body telling the government to behave themselves. And at the moment, there's been some controversies in that regard because it has had some political struggles with the federal government under Tony Abbott, with regards to this criticism of the government's policy on offshore detention center in Nauru. Um, we may have a media article for that has been uploaded on the online portal. It also plays a very important function of dispute resolution. This is if one party has a complaint against another party on the basis that another party has violated human rights, then they can submit a formal complaint to the AHRC. The complaint needs to be based on legislation, so I can't just say that you violated my rights, but it has to be clear that the rights that have been violated upon are based on legislation. The AHRC would then conduct what the process known as conciliation. This is like mediation, except that in a conciliation, the conciliator is a third party person that can also provide legal advice. And that's important because at the end of the day, these are legislation-based complaints. If the conciliation fails, then they could lead to a report by the president of the HRC, which can then lead to court action. And we can see in a moment in the next slide how that chart actually works. Now, it's important that you make the point that basically this works really well because it is cost effective. Actually, it costs basically nothing for a person to complain. Well, you do have to make a deposit, but however, you do get the deposit back if your complaint is successful, and that it leads to conciliation. It also provides possibility for court remedies down the track. So it's important to understand that this is not a judicial body, but it can provide pathways to judicial solution, which means legal certainties. All right. So how does it work? Well, basically, as you can see in this flowchart, if you go from the left, let's AHRC first gets a complaint by party A against party B, and then you'll go and investigate complaints. Usually by talking to both sides of complaints. And then after that, after you get all the available evidence, then you conduct further the process of conciliation. If conciliation is successful, then that's where the matter ends, and both sides will depart basically having achieved a conciliatory outcome. But if conciliation, however, is not successful, then it warrants further investigation. Then after further investigation and talking to other witnesses and so on, then you get two parties could come back for another round of conciliation. If that round of conciliation is successful, then basically the matter ends right there and everyone's happy. But if conciliation is not successful, that's where the president issues a report making a judgment as to whether which side's at fault or whether discriminations occur and what might happen as a result. Now, that's not binding rulings, but however, if the complainant can use that report as the basis of legal action. Let's see how that actually works. So this is a case called Jones and Tobin 2002, where it happened in the Federal Court of Australia. Basically, it's a case involving a guy called Dr. Jeremy Jones. He lodged a complaint against Frederick Tobin, who was a neo-Nazi supervisor, and he created a website that denied the Holocaust on a web server located in Australia. The complaint was based on the Racial Vilification Clause, Section 18C of the Racial Discrimination Act. So obviously both sides attempt reconciliation as per legislation require, but however that failed, and that led to court action in the Federal Court of Australia. And the Federal Court of Australia ruled in favor of Dr. Jeremy Jones. So therefore, the web server had to be shut down as a result. Now, one little post note is that Frederick Tobin then later on was actually arrested in Germany and found guilty of breaking German law because of what he did back in Australia. So it's a little side note, probably not directly relevant, but it's interesting to see how legal action in one country can lead to legal action in another country. Okay, so what can you draw from that? Well, basically, I would argue that in regards to at least domestic mechanism, the domestic statutory authority actually works quite well in terms of enforcing human rights. Obviously, because they are enforcing domestic legislation, the issue of sovereignty is a no issue, obviously. So it works, in fact, quite well. So let's get to the point. How would you write that in a possible 7-marker or 8-marker in the HSC exams? All right, well, I'm deliberately created a question that has got nothing to do with statutory authority on appearance, but I'm going to deliberately use statutory authority and see how I might structure 2 paragraphs or so in response to that question. So let's use statutory authority as examples for this one. All right, so I'll start by going very quickly, into what statutory authorities are and what the general role they play. Probably take around 2 sentences or so. And then I'll start by basically going to treaty-based committees, and I would only use one committee in this case, which is UNHRC. I would definitely talk about its role in monitoring compliance with ICCPR, but then I will go into basic, and also go into its quasi-judicial functions. I would then use the tune illustrator case to illustrate how that works and make the positive point that it can lead to compliance. But then I could also use the blessing illustrator case to illustrate that basically because of sovereignty, um, nation state don't have to necessarily follow the rulings of the UNHRC. Then I'll go into domestic statutory bodies. And again, I'm only going to use one body in this case. That would be the Australian Human Rights Commission. I'll define its role. I'll definitely mention, in this case, the legislation, where it comes from. And also, I'll definitely make the point about its dispute resolution mechanism, which is conciliation. Then I would then go to the case of Jones and Tobin, which lead to the point basically that, well, in fact, it works really well. And I would really encourage you to use a point that it basically is cost effective and that it can lead to just outcomes. Okay, so I wish you all the best in your exams and in your studies. Definitely feel free to pop any questions along, and I will see you later.